Good morning, afternoon, evening, whenever it is. It's morning my time, not legal advice. Obviously, it's not legal advice. It's just opinions only. I have to say that every time, like I always do. Please draw your own conclusions, use your own judgment, etc. But this is obviously just my opinion as I stated. So I said that many times. By the way, it may be noisy in the background because I hear an alarm going off. Somebody is sawing above me. So hopefully this will be a very entertaining sounding session, let's say, here today. I'm going to talk about GTII, obviously, in the hearing that went on yesterday, and I'll bring you up to date. Before I went on, I looked to see if there had been a ruling. There had not been as of about 20 minutes ago. So I'll presume there's not going to be a ruling. I did contact counsel yesterday, or no, excuse me, yes, today, and he said they'll get a minute order and he'll advise me as soon as they get a minute order. A minute order is the order that's released from the court, and it will be electronically sent to the attorney, who then forward it to us, let us know. Of course, before we get into that, I have a few things I just wanted to briefly address. One of those is a repeat, but I liked it so much I'm repeating it. Why did the can crusher quit his job? Because it was soda pressing. What did the energy company's CEO credit her success to? A series of power moves. Business is up and down, said the yo-yo salesman. And last but not least, how many optometrists does it take to screw in a light bulb? One or two? One or three? Three or one? It's a deep joke there. Anyway, so I observed the entirety of the hearing yesterday. It was held in Las Vegas. The hearing was before Judge Williams. I don't practice in Nevada, so I never had seen Judge Williams. Seemed like a very affable guy. He was in good spirits. He was previously a practicing lawyer, so as a result, he kind of knows what's going on in the legal world in terms of practice. So it was interesting to hear him. So how did the hearing go? So the hearing was on the 9:30 calendar, which means that there's a bunch of matters set at 9:30, and this particular matter, our case, was set on the 9:30 calendar. There were a few matters that were before our case that were heard, so we probably were heard sometime around 10:15 about a.m. or so. The other matter is not particularly interesting, but I listened to hear how the judge reacted. And the way it works is, so some attorneys would appear remotely and some attorneys would appear in person. If they appeared in person, the plaintiff, the party bringing the action, would be on one side of the courtroom, and the defendant's attorney would be on the other side of the courtroom. The attorneys who represented the shareholders, my hat's crooked. Why don't you tell me that? The attorneys who were representing us, our interests, there were two of them there. One of them spoke. The other one was at counsel table and was there as backup. From the other side, there was a local attorney who didn't speak, other than the fact that the attorney who argued on behalf of GTII and that group was from California, so she had to be specially admitted for this case in Nevada. It hadn't happened yet, so there had to be a little procedural little thing done, and she spoke. The other attorney did not. Also was the attorney for the potential receiver, and there might have been an accountant there too. I don't know if any of the other parties were there, any of the individuals. Obviously I wouldn't have recognized them, any of them. So after the few cases went ahead of us, then our case went on. There was a whole pile of papers on the judge's desk overlooking the courtroom. And obviously he's looking at a computer and he has stuff on that, but he was asking about locations of certain documents, etc. So seemed to be conversant that there were a lot of papers that were filed, because as to this application, and the application itself was to appoint a receiver and to get a TRO, a temporary restraining order, to block certain actions like sale and distribution of cash and a bunch of actions. So it was a combination effort. And it was set on short notice, even though I know it seems like it took a long time, but it was set on short notice. So it came ahead of schedule when it would ordinarily be heard. And the only issues that are on the table were the issue about the receiver and the issue of the TRO. The underlying lawsuit suing the directors, et cetera, for breach of fiduciary duty and trying to recapture whatever was taken, those are ongoing. That's kind of ongoing. So if you can look at this as kind of like a split proceeding. The proceeding that happened yesterday was just immediate stuff that needs to get handled, try to get a receiver in. And the bigger case goes on down the road. Now, technically speaking, David Reichman is no longer CEO of the company, I guess effective August 1, apparently. He's no longer the CEO. I don't know if he's a member of the board of directors still. He might still be chairman of the board. I don't know. But I don't think he has any other position currently. I think Mr. Rabari, effective August 1, I think, is the CEO, COO, and I think, because I heard reference, sounded like he was on the board. I'm not certain of that. I don't know if he holds any other positions. But that's what was disclosed. So, and by the way, just so we're bringing you up to speed completely, I checked this morning, Alpine, those cases, and still no decision by the appellate court. It's been quite some time. I think we're like 4 months past when the oral arguments were. But anyway, so that's that. Okay. So the way the hearing works is, so the judge has all his paperwork, and I think the judge was somewhat familiar with the case. He had looked at the paperwork, and then after, the reason why they don't rule while they're sitting on the bench, depending on the matter and depending on how strong the law clerk is and depending how much time they have, sometimes they'll rule before the matter. You'll get a tentative ruling. You'll argue about the tentative ruling, and that'll end up most times being the final ruling. That's in California. In Nevada, I don't know, and I don't think there was a tentative ruling, and the judge had not made a ruling. And as of now, I don't think he's made a ruling when I checked the site as of this morning. And what the judge will do, the judge was listening. I thought he was listening very carefully to what everything that was said, and he asked a bunch of questions. And at the end, after it was done, he'll take all the paperwork, he'll take his notes and his recollections and whatever his conclusions were at the time, and he'll kind of figure out an order. This kind of order doesn't necessarily have to be this long document. It could be fairly short, could be a couple pages, whatever. So it doesn't require a whole bunch of time to complete the order. And I think our attorney thinks one way or the other, because I don't know how it's going to turn out, one way or the other, the order probably will come out in the next couple of days. That's what he's expecting. Could it be longer, of course, but that's what he's expecting. Now, even if the receiver is denied or something else, the case still goes on. So just to issue the receiver, and based upon what was said yesterday, if there are certain actions that are ongoing that would have to be completed, or else those might be construed as problematic. So in other words, like yesterday on the record, it was indicated that there's ongoing audits. So if the audits somehow don't occur or haven't occurred, that would be problematic. So I presume all that stuff is ongoing, and that stuff is good. So now getting to the hearing itself. So the hearing itself probably lasted about an hour. I would say if I was going to split the time, probably around 35 minutes for plaintiff side, 35, 40 minutes plaintiff side, 20 minutes defendant side, 25 minutes, something like that. The attorney who I've been dealing with was the one arguing for plaintiff, and the attorney who represented GTI, who argued I've never spoken to, she seemed very intelligent and argued well, but I don't think she had just my opinion, I don't think she had the grasp of the facts that our counsel had. It may just be, she hasn't spent as much time on it. She may not be getting as clear information from whoever's supplying her information, but it seemingly that seemed like a distinction between the two sides. It appeared that the plaintiff side our attorneys had a better grasp of the facts. So the argument was, our side argued first. The basic argument was there's been non-compliance with filings. They haven't filed. There's a risk, risk to everybody. Nobody can trade. There was a prior problem. There was issue about the discussion about downlisting, distribution of shares. There was reference to the masseuse. There was reference, kind of a general discussion of how there was immediate contact between our attorneys and their attorneys, and it seemed like they were at least it seemed like, from what I was told, there may have been a little bit of delay tactics going on. But anyway, it was laid out basically that they haven't done the filings. There's been a bunch of distributions that are problematic. There's been some transactions that have been problematic. There's been false statements. I think he said false statements because in some of the filings with the SEC, where they've indicated there was no stock or bonuses received, in the same document, they indicate to the contrary. I think that's what was disclosed. So kind of went over the same stuff that we've gone over. Now, all that stuff had been written out. So big, long briefs, probably, hundreds of pages, literally, because there was exhibits, etc. Hundreds of pages of documents. This kind of summarized the high points. That was our side. That was the first pitch that was made. The other side came in and they argued basically procedurally. They argued about the 10% issue. And they generally argued about that that everybody was great. I'm summarizing, but it was basically more so a procedural issue that they can't do it because they didn't have 10%. They focused on one particular shareholder. They tried to draw a distinction. And that was the large part, their argument, purely procedural, which kind of was surprising also because they had about a month since the complaint was filed to prepare some type of opposition, more substantive. I was kind of surprised. I thought they could have done a better job in terms of their paperwork. So that counsel who was representing the defendant, GTII, etc., she argued, I'm guessing, it seemed like about 20 minutes. I'm on and off. There may have been a few questions by the judge, just as there was in the first section, but she really focused on procedural issues, venue, service, and the 10%. And this is an interesting point here, and I'm going to address this really quickly. So in Nevada, if you can present 10% of holders of stock in an action based upon breach of fiduciary duty or along those lines, you can bring an action to get a receiver, TRO, etc. Only need 10%. But seeing from this particular hearing, you better make sure that you have documentary evidence establishing that. In our case, for example, I think in the paperwork that was submitted, there's 200 or more individual declarations where each shareholder indicates the number of GTII shares they own. And because it came up as an issue, anyone who might be considering that or be attached to a stock, etc., in Nevada or in some other jurisdiction or counsel who might be trying to pursue that have to be really careful there, because to the extent your judge is a stickler, you better make sure you make a proper showing of your 10% ownership. Now, separate and apart from that, and before I get to the last section of the hearing, separate and apart from that, there's a code section in Nevada that deals with receivership, and that's the one that's the 10% stock requirement. There's another general code section that talks about receiverships in terms of equity. So if the situation requires, in good faith, requires the court to intervene, and the court has intervened in the past in situations like this, even though there's not a direct statute on point, if there's some kind of misconduct or perceived misconduct or other thing like that, the court could still impose a receiver without that 10% requirement. And that was discussed during that hearing also. So again, if any company is, any shareholders, any company, any attorneys are thinking about pursuing this in Nevada, be careful about 10%, but understand you also have an alternative way of approaching it that came out during this particular hearing. All right. So there was a bunch of discussion, by the way, about that 10% both ways and about the other equity statute during the hearing. I don't remember what section specifically. It was whether the defendant was speaking or whether it was the initial section. But after the defendant spoke, so I said, we give our initial pitch about the non-filing, the status, the press, the prior delisting, stock issues, monetary issues, the $4 million cash, et cetera, all that stuff. They came back with strictly pretty much a procedural argument, attacking that. And then the last section came back to our side and went back to, somehow we arrived at the issue of the stock distribution in January of 2023. And if you all recall, in January, I think it's like January 25th of 2023, something on the order, and I'm estimating, this may not be exactly correct, but it's probably ballpark, about 65 million shares were issued that day, equating to something like on the order of $98 million for that particular day. And if you recall, of that 65 million or so shares in June of 2024, so that's 18 months later, about 36 million of those shares were canceled because they were claimed to be inadvertently and or erroneously issued. So somehow the last section of the hearing, and there was no rebuttal from the defendant. So this is the last thing the judge hears. This is the discussion. And again, may be meaningless. We don't know. I've been in plenty of court hearings where I thought the judge thought something and they didn't, and I was wrong. So I don't take anything for granted, but that's where we were going, and that's where it ended up. So the discussion was about those shares that were issued. And what I found interesting is our counsel presented the pitch on the 10K that was filed that talks about the issuance of those shares. It says they were issued, but it also says they didn't get the bonus or stock award. So it's kind of inconsistent in what it says. And I don't remember if it's in there or another note, but some note, I think I saw it. I'm pretty sure I saw it. My recollection is there's a reference to those shares being issued for past consideration, for past services provided, past work provided. Now that's kind of, if that was the reason, that's kind of, I'm skeptical, let's say, of that. But during the hearing, so just to kind of give you the concept, this is the very last part. So our counsel is saying, here's the last 10K. They haven't filed the current one. They had the bogus auditor. And on this 10K, we have seemingly inconsistency because on one side, they said they don't get a bonus, they don't get stock. And the other side, they're disclosing they got 65 million shares, or 65 million shares were distributed approximately. And then when the attorney in this lax session, I think this is about the only thing she said, it was very short, her involvement, the very last section. I think I said she didn't respond, but she did. It was in the middle of it, was very short. And in it, she said, and I was amazed by this, she said that those shares, and she didn't have an explanation, I don't know if she was asked, but there was no explanation for the other portion of the 65 million shares, but of those 36 million shares or so that were canceled in June of 2024, that were issued in January of 2023, she said they were issued based upon a prospective deal closing. So they had a deal they were working on, hadn't closed. The directors issued themselves shares before the deal closed. The deal never closed, by the way. The judge, when she said that, he paused. He looked at himself. So you're trying to tell me that it's okay, and I'm paraphrasing. You're trying to tell me it's okay for management to pay themselves before a deal closes, as opposed to waiting for a deal closes? And then he referenced something on the order of management. He made a remark. He didn't talk about fraud, and he specifically said, I'm not talking about fraud or anything like that. I'm not going to get into the arguments about fraud, but this appears to be management, improper actions by management. It is what it is. They shouldn't have issued the shares before the deal closed. Sounds kind of, this is my words, not really supportable. And she acknowledged it. She, being the attorney for defendant, was the one who brought it up. So now thinking about it, so the judge kind of reacted like that. And then, and I think I did a video on this, he focused on those same words where they canceled those shares. He specifically said, what does erroneously and inadvertently issued mean? What is that? Literally, that's how he responded. So that last section, that last 15, 20 minutes of the hearing was solely focused on that issue. That issuance of shares before a deal even closed, the cancellation, the use of that terminology erroneously and inadvertently, and the judge left it at that point. That literally was the end of the hearing. So the end of the hearing, I thought, ended up on a very high point. I thought it was the highest point of the hearing. I literally, this happens a lot. If you participate in hearings, you do your part, you're all excited because it's great. The other side then throws up a bunch of stuff, and then you don't feel quite as good about yourself. And then at the end, you come back and you get an opportunity to kind of clean it up. Now, what's oftentimes what happens is the judge might give the other side another chance to clean up the mess that they've created. So in our hearing yesterday, I've been in plenty of hearings. So after our attorney finished, sometimes judges will go back to the other side and let them kind of try to clean up. Yesterday was not that way. The judge was, I think, really moved that prepaying stock to management. I think he was really moved that is just not kosher and improper. And that's where the hearing ended. So at the end of the hearing, I felt positive about how it went. I thought, again, since it was in Vegas, if you were going to do Vegas, I would say we are at least a modest favorite, and modest favorite to get a receiver appointed or some type of injunctive relief, as we asked. Now, it may not go that way, but I'm just saying the judge seemed to get it. And judge could deny it, but the judge seemed to get that whatever the conduct was, it was not, didn't seem to be kosher. Now, what's interesting beyond that is, so I told you in that last discussion, there's a 10K, and in the 10K, it seems to be an inconsistency where on one hand, it says the directors didn't get any bonuses or stock. And on the other hand, they're disclosing the distribution of 65 million shares of stock. And then the attorney yesterday, and they say, as to that 65 million shares, somewhere they say it's for past consideration. And yesterday, the attorney said it was for future consideration. So now there's three stories, as far as I understand. There's, according to defendant, nothing. According to defendant, past. And according to defendant, for the future. I think we've covered all bases. Maybe in a parallel universe, they're going to be getting stock too. I guess that's possible. But I found it interesting. When I indicated I didn't think the attorney, although she seemed very competent, she was very skilled, I just didn't think she had a great grasp of the facts. And not blaming her, just that it's fairly confusing, and I don't know what her clients may have told her or not told her, and she just may not know, or maybe she didn't, or maybe she decided not to deal with them. I'm not going to debate her strategy. She might have had a different strategy, etc. I know her interest and her focus again was very procedural as opposed to substantive. That's a safer way of going, also, if you're a defendant, because you don't want to take a position. But again, here we go. We have apparently three different views by defendant on these shares that were inadvertently or erroneously granted. They didn't happen. They were from the past, for work in the past. They were for consideration for stuff in the future, but nothing in the present, obviously. So with that being the end of the hearing, I thought it was positive, but who knows where it's going to end? This is all just opinion. Who knows? But I'm basing my view on how it ended, on the topics that were discussed, on the seeming fact that the judge seemingly got it and this is irrespective of everything else. So this is, when the judge goes back, so let's say he focused on that particular issue and he thought, let's say and I'm again speculating because I don't know, but let's say for the sake of discussion, he believes that's problematic. And in and of itself, that's enough to justify appointment of a receiver or issue a TRO. And he could do it either on the basis of 10% or on the fact of just equity to appoint that. But when he goes back, he's going to look at the entirety of everything. And there's plenty of other issues. And I think if he, after that hearing, if he is inclined to grant us relief after he reviews all the paperwork, I would think he'd be more inclined. But that's just my speculation. So I think we'll get an answer in the next couple of days. As soon as we get an answer, I will obviously let you guys know so we all know. But understand, like I said, it's not going to be an end of the case either way. If we get the receiver appointed, obviously, then they could take over. They would be able to take over and get whatever needed to be done, work on, reestablishing a position so it can be traded by normal human beings, etc. If it's not, then we're going to be watching very carefully existing management who's already indicated what they're going to do. And even though, our attorney argued, this is what he said, it's like the hen watching, no, it's like the coyote watching the hen house. In other words, Mr. Rabari was hired by Mr. Reichman. He's been involved. So would it be a good idea for him to be receiver or in charge? Or would it make more sense for someone who is completely unrelated and not involved to take charge? You know what my opinion is on that, but a judge could decide otherwise. So I can say, I saw the judge. I thought he was fair. So whatever he decides, that's what he decides. I didn't think there was anything problematic about that, and I can't say that about all judges. So I think that was good. So I'm going to leave it at that point. 28 minutes in. So I thought it went well, but we don't know definitively. When we know definitively, I will let you know. And that's it. So everybody be well, take care, and I will certainly give you the update as soon as it comes in. Everybody take care, be well, have a great day, and hopefully we're moving in the right direction.